propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.
Good morning, everyone. Welcome to this exciting panel on essential patents and FRAND licensing. Today, we have a fantastic lineup of speakers who will provide unique perspectives on this highly relevant topic. We have representatives from Europe, the United States, and Brazil, of course, bringing their expertise to shed light on the enforcement and licensing of essential patents from various angles. Technology is advancing rapidly, as we know, and along with this progress, the importance of standard essential patents and FRAND licensing. In this context, the 5G standard and the Internet of Things are transforming the landscape of SEPs and FRAND licensing. A large number of industries, cars, domestic appliance, buildings, healthcare, utilities, will be powered by 5G connectivity, or are already being powered to some extent by 5G connectivity. And this means that billions of devices will be connected to the internet. As a result, many new companies coming from different industries will have to take a license for the use of SEPs. However, these companies generally have little, if not zero, experience with SEP licensing. In addition, the number of standards used in the IoT will become more complex. Besides connectivity standards such as Wi-Fi, 5G, and Bluetooth, IoT objects cover different quality and security standards. So SEP and FRAND licensing have been hot topics for some time, and there are no signs of that changing anytime soon. On the contrary, these concepts play a crucial role in promoting innovation, ensuring fair competition, and enabling access to essential technologies. And our aim today is to explore how these issues are approached in different jurisdictions, Europe and the US, and how the international landscape influences or may influence the Brazilian case law and legal framework. Switching to Portuguese very briefly, eu gostaria de apresentar em português, por uma questão de deferência, a nossa primeira palestrante, cuja presença muito nos honra, excelentíssima senhora doutora Caroline Tauk. É um prazer e uma honra contar novamente com a sua valiosa participação no evento da ABPI, sempre com brilhantes contribuições, e hoje não será diferente, não temos dúvidas. Muito obrigado pela participação. Voltando para o inglês rapidamente para apresentar os demais palestrantes. Switching back to English very briefly, Dr. Clemens Heusch, it's a great pleasure to have you here with us today. We are excited to learn from your extensive experience in dealing with SEP and FRAND licensing disputes. Dr. Clemens Heusch is Vice President at Nokia and heads the global litigation and disputes team with a strong focus on multinational IP litigation. Presenting the US perspective, we are delighted to have Dr. Rufus Pichler, a partner at Fenwick West, a US-based firm. Dr. Rufus Pichler will share his extensive experience in the American landscape, providing insights into key cases, regulatory frameworks, and addressing the unique challenges in FRAND licensing. I will not be reading their bios of our highly qualified panelists. For those who are interested in learning more about them, their bios can be found on the website of the event. And quickly, before I hand it over to you, Márcio, very quickly regarding the format of the panel, Dr. Clemens will start the panel, followed by Dr. Rufus, so that we first have the international landscape. And then, based on the international landscape, Honorable Judge Caroline Tauk will provide the Brazilian perspective on the matter. The idea is for each presentation to have 20 minutes, allowing 20 minutes of questions and discussion at the end. But there is no rush, so we can extend the duration if necessary. With this introduction, I hand it over to you, Márcio, for your additional comments before we begin. Márcio, please.
Thank you very much, Philippe. We are very honored to have such a distinguished panel here with representatives from the judiciary, from the private practice, and from the corporate team. So we are very delighted to have you all here, and also a very great audience right now. And to discuss this within our scientific committee meeting, and specifically in our committee, which is the International IP Law Committee, regarding a matter which is essentially international in this regard, because we are discussing FRAND licensing terms and standard essential patents, which usually are global in nature, are international in nature. So most of the negotiations are dealt in many countries, whether in San Francisco, in Germany, in Switzerland, or other places. So it's really an international matter. And for no other reason that now we have a WTO panel, the DS-116, which is something that we will have to further make additional studies. So I'm pretty sure that this panel will be very enlightening for all of us. So without further ado, I will transfer the floor to Mr. Clemens, and thank you very much for all of you.
Good. Thank you, Philippe. Thank you, Márcio, for this nice introduction. I'm very happy, very honored to be here today to speak to you all. And yes, let me just maybe tell a little bit about my person. As Philippe already said, I am heading the dispute resolution team at Nokia, and Nokia is a technology company, so this means that this automatically includes a lot of IPR disputes. And as many people consider Nokia still to be as one of the biggest handset makers in the world. Actually, we were the biggest ones for some years, but that is now a long time ago. So very often people on the street ask me, so does Nokia still exist? I can confirm we still exist. I still exist. Nokia has roughly 90,000 employees, and we make annual revenues of about 24 billion euros. How do we make this money? Most of this money we make with network infrastructure. So this means the base stations and everything else what is necessary so that all your smartphones work on the market. We also make roughly 1.5 billion euro with licensing, so without licensing our portfolio. Sounds like a lot, but it's not, because on the other hand, you have to see that we invested in that technology by today roughly 140 billion, and we on top of that every year another 4 to 5 billion. So let's say about 1/3 of our annual investment comes back through licensing. On the licensing, I quickly scrolled to the participants here, and I saw that we have many people who are very familiar with this, so I will not too deeply explain to you how this all works, because I just assume that much is known, but only for those who don't deal with this on a daily basis. Let me very roughly summarize this. Yeah, so from the time when we were in the handset business, actually from day one of digital communications, we were involved. We did R&D, we contributed to the standards, and this means that, of course, we also have a substantive patent portfolio. We have roughly 20,000 patent families, now about 5,000 families for 5G networks. We continue to develop. Now we are working very extensively on 6G. So that is the next one in the pipeline, which will probably be launched in 6 or 7 years. So it just continues. We continue our engagement, we continue our investment, and the technology continues to develop. Yeah, and as you all know, these standards are publicly available. So therefore, the market entrance barrier to this market is lower than ever. So that's we saw this, for example, with the automotive industry. They wanted to make their cars, which basically consisted of wheels and engines, but now they wanted to make it kind of smartphones with wheels, which now today have all kind of connectivity for entertainment, but also for safety, for traffic, for emergency calls in case of accidents. It's all included now. So the telecommunication, the automotive technology had the big advantage. They didn't need to develop communication technology. They could use what was on the shelf available. So they could enter kind of telecommunications market with very, very little investment. And this is possible because other companies have invested. And this, of course, means that there must be a fair compensation. In an ideal world, people would come to IP owners before they enter the market and would say, look, I want to launch a product. I need a license from you. Could I get one? That is not the reality in our business. Our reality is that people enter the market, and if I would say they hide a little bit and wait whether they are caught. If I say this in more neutral words, let's say they wait to be approached, and if you approach them, some people, let's say, don't even reply, others reply, but it takes extremely long. It can take half a year to agree on an NDA, then it takes the next 1 year to have technical discussions, and then it can take another year to have commercial discussions. And when you think you are very close to signing, then you suddenly get an email, oh, our negotiation team has changed, let's start from scratch. So it is not easy. And I'm not talking about everybody, I'm just talking about, let's say, some exceptional cases, but they do exist. So what do we do if we really cannot get them to sign a license? Then we have to sue them as the last resort. And just to give you here also some numbers, Nokia has at the moment about 200 license agreements. 5 of those are the result of litigation. So that is not the normal thing, as it seems somehow if you read the IP news, but it is still the exception. But it happens. And then there has been long discussions, what is the right remedy? So there were arguments, if that is an SEP, something everybody has to use, where you have a FRAND commitment, then there should not be injunctions. This was in Europe for a long time argued, and then ultimately in 2015, the Court of Justice for the European Union has decided in this famous Huawei versus ZTE judgment, yes, there can be injunctions also on SEPs, but only if, I simplify a little bit here, only if fair and reasonable licenses have been offered. And that is exactly the issue we are in today in Europe. So this means in most cases you see there have been negotiations, there have been offers and maybe also counter offers, but people just cannot settle. And then the question is, should then there be injunctions? You sue them and you bring this to court, and then there are basically now two very, let's say, two kind of approaches which we see quite often. And to simplify, let me call it the English and the German approach. What the English do, and they were a member of the European Union until 2 years ago, so this means they were also bound by the case law of the CJEU, by the Huawei versus ZTE judgment. The English said, okay, first we look whether there is a valid and infringed patent. And if there is one, we kind of ask the parties, shall we look into what would be a fair license? And then the parties can say, okay, if you tell us what would be the right amount, then the defendant has two possibilities. He accepts it, and then you have a global license. or he says, no, I will not accept it because I don't want to, or I don't like it, I disagree, whatever. And then he would be considered for the UK as an unwilling licensee because he does not accept what the court considers to be appropriate. And so then he would be excluded from the UK market. Also, this means it is only an implicit setting of FRAND with effect only to the UK market. The German courts have a slightly different approach. There were 2 Supreme Court judgments in 2021, both between Zisvel and Haier. Zisvel is an Italian patent enforcement entity. Haier is a big Chinese company. They had a FRAND dispute, and at the end of this FRAND dispute, the court found that Haier was unwilling, and also here the main point is that the court said they were not enough engaging. They said, as I said earlier, they entered the market without a license. So they had a head start, they had an early start. And the court said that is illegal according to patent law, but this does not mean automatically that you will be injuncted. But if you have a head start, then you should do all you can in order to get back into legality. So this means they have to be very proactive. They have to push the negotiations. And they said, then it's inappropriate if I have a head start and then I ask for all kind of ridiculous information. Could you provide this? Could you provide that? And then you delay. And then you say, oh, next meeting, I have only my next available slot in September. And so on. They say that is not acceptable. They should do all they can. And so therefore, Haier was found in both situations to be an unwilling licensee because they did not, now to quote again the UK court, the unwired planet case, they did not, they were not willing to accept FRAND for whatever it means at a quick time. So these are the 2 different approaches which we currently see in Germany and in the UK. And if you look at the other European jurisdictions, there are very few cases, some from France, some from Netherlands. They tend to do it a little bit more the German way. Has probably also historic reasons and fundamental reasons, but in the end, they all agree here pretty much. The problem is now that we see that, let's say, the defendants are getting smarter. So especially Chinese companies, for example, in these days, they are not as clearly unwilling anymore as they used to be. We see that they hire top-tier law firms in Europe, that they are very carefully testing the red line. So how much do I need to do in order to be considered willing? But at the same time, I of course don't want to do anything more because I don't want to, let's say, pay more than I absolutely have to pay. That is a challenging situation. And on top of that, we now see the issue of the licensing level. And here I come now back to the automotive dispute, which I already mentioned. In the automotive dispute where we sued Daimler, we had one additional challenge. And this challenge was that Daimler said, look, Nokia, all the connectivity is in a small black box. And this black box we buy from one of our suppliers, and we have not the slightest idea what's inside that box. So we cannot really talk about this. So why don't you speak to our suppliers? We tried that. We spoke to the suppliers, but what did the suppliers say? They say, why don't you speak to our suppliers? And so on. So you get all the way up in the value chain. But there's another problem. And the problem is, what is the fair rate? Of course, Daimler has all resources and all possibilities to hire patent attorneys, to hire consultants, to look at the IP situation themselves. But the real reason why they didn't want to do this is not a lack of knowledge. It's a financial issue. They think if you license a car, it will be more expensive than if you license a tiny, tiny chip. The chipset costs whatever, $20. The car costs $100,000. But in my view, that is a wrong argument. And I will tell you why. Because what do we license in the end? We don't really want to license a chip because with a chip, you cannot do anything. We want to license always the end products for 2 reasons. First of all, only in the end product, all the patents are implemented. And let's say because a chip by itself cannot do any data transmission. It needs all the inputs from the user interface, from the sensors, it needs the antenna, it needs the electricity. So therefore we think the component does not infringe, only the end product infringes. But on top of that, not at all, the claims are not all process claims. The claims, there are also many, the claims are not only product claims, but also many process claims. And the process is only done in the final product, because a chip by itself will never perform a process. It needs to be implemented, plugged into the car, only then it will start becoming active. Before that, it doesn't even have electricity, just to give you one example. Now coming to the financials. Should there be the same rate whether you license Daimler or whether you license the supplier or the supplier of the supplier of the supplier of the supplier? My view is yes, there should be the same price, for the simple reason we always want at the end only to license once in the value chain. And in the end, it's the humans, the individual, who makes use of the invention by driving a car with all kind of comfort, or with all kind of security, with all kind of informations, and the other one who takes advantage of the connectivity are the car makers. And I will give you now a few very obvious examples. The car makers permanently, whether you want it or not, collect data from you. So when you have a connected car, it permanently sends you tracking information. Your car sends tracking information to the car makers, which gives them a lot of good information for improving their products, but also on the behavior of their customers, of the needs of the markets, of many other things. But two other examples. One is Dieselgate. So German car makers were found to have unallowed software in their engine control, which produced too much pollution. They had to update the cars. In old times, they would have to call all the cars into the service. They would have to give the people rental cars. They would have to pay the service garage. All this cost a lot of money. What do they now? Over the air, in the middle of the night, they make a software update, cost almost nothing, and you will not even realize it. You will just be surprised why the AdBlue in your car is much quicker consumed, but that's another issue. My next example is my car. I drive a BMW, and I got a call from the garage. They told me, Clemens, your car informed us that you need new brakes. So I immediately made it. I thought brakes are probably important, who knows? I made an appointment, and I paid more than 1,000 euros for the new brakes. And afterwards, I thought, actually, why didn't I compare with Free Garage or others, so that I probably would have saved a lot of money. But they made a lot of money just because they had this information head start, and they called me. So there's a lot of value also which the car makers take. And so therefore, to make a long story short, my view is the value of the technology is always the same, no matter where in the value chain you license. And so therefore, the rate should always be the same. If people would all accept that, then we wouldn't have any dispute where to license in a value chain. The point is that that is just not the economic reality. And you might have read there's a big successful pool now. It is called Avanci, which charges per connected vehicle $15 US. And by that, you basically have all patents you need for a connected vehicle. Basically, there are a few exemptions. And $15, you will say, for a car seems very reasonable. That is, let's say, compared to other things, that's probably the price which you pay in the US or in Europe for one car wash, for a lifetime license to 10,000s of patents. However, if you look again at the chipset, and then which costs $25, and then you say you should pay $15 for a license, they will say absolutely impossible. We make 10% profit, $2.50, so we cannot pay $15 for a license. Of course, they could just increase the price of their chipsets and say, look, you pay $15 more, not $25, but $40. Therefore, you get a fully licensed chipset, and you don't have to bother about all these things. Would be possible, would be easy, but that is just not commercial reality. We have seen that it's not working at the moment. So therefore, we go back to square one, that the cars should take the license. Yeah, these were my comments on the value chain. And then let me just make one last comment. Efficient enforcement possibilities are for us absolutely key, including injunctions, and for a very simple reason. We see that without injunctions, no one will take a license. And I told you that we conclude basically far more than 90% of our agreements without litigation. Are these all just honorable and good persons? Maybe yes, but I would say Probably not. Probably they only do this because they know there's always a threat that if you don't act legally, you could be injuncted. And we see this in all kind of life. I mean, I see this with my children. They know that they should behave because otherwise there might be a consequence. So they behave properly, not because they are nice. No, they are nice. No, but mainly they behave properly because they don't want to face the consequences. And that's the same with injunctions. Without injunctions, nobody will ever take a license. And we hear the argument, yeah, you could sue them to take, you could hear the argument, you could sue them to take a license. That is in practice not possible because a license is always looking forward and nobody knows what they are planning to do looking forward. We also hear you can claim for past damages. It's also in practice not possible because you would have to do that patent by patent, country by country. So you would have to file with 5,000 5G patents, which are validated in more than 100 countries. You can multiply how many lawsuits you would have to file. No lawyer wants to earn so much money. That also doesn't work. So this brings me back to my original point. We need injunctions in order to bring parties to come to the table and to take licenses. Only that way all the investment R&D pays out, and we only then are able to fund our investment in 6G and in 7G. Without return of investment, those who would use our technology would have an unfair advantage and we would not be able to fund future technology. With that, I think I leave it for now and hand over to Rufus.
Perfect. Thank you so much, Clemens, for your contribution, covering very interesting topics of the FRAND licensing, and enforcement. I'm sure we will have many questions at the end. I have a few questions to raise, and yes, now we move on to you, Rufus, please.
Terrific, thank you. I'll share my screen. One thing I need to note is that the threat of an injunction for my children, that seems to be a valuable remedy. Okay, let me. Right. Can you see the screen here?
Yes, it's on.
Yeah. Okay. Yeah. Very briefly. So I'm a partner at Fenwick West. Actually, I need to turn off the translation here. Hold on. I think it's 1 second. Okay. There we go. Sorry about that. So I'm a partner at Fenwick West in San Francisco. I practiced as a technology transactions lawyer for 25 years almost now. And so Fenwick is one of the predominant technology focused firms in the US. We represent patent holders, implementers, technology companies more broadly. On the SEP side, I think, we've been on all the sides, implementer side, licensing discussions, extracting value from portfolios, and on the litigation side. And I'll give you a bit of an overview. I think in the US here, one of the leading cases I think that has become very influential was the 2013 Motorola Microsoft case, and I'll spend some time going through that because it was one of the seminal cases establishing what a FRAND royalty is. Very influential, very controversial. I think it's one methodology among others. But I'll go through that and some of the follow-up cases that really kind of have started to shape the landscape since for about 10 years now. I'll quickly go over component level versus system level licensing. That's something that Clemens alluded to. Is it appropriate to license at the chip level in that case, or at the system component handset level, car level? That's been a very active discussion in the US as well. Talk about injunctions, where I think the US has a bit of a different approach than many other countries, and about International Trade Commission exclusion orders. So that's another remedy in the US, essentially barring the import of products into the US. It's a different judicial channel, but quite effective, similar to injunctions, where the ITC can order if there is patent infringement, that foreign products cannot be imported into the US. And they'll spend some time just on policy developments. In the US especially, it's a very a politically important topic, depending on where people stand in terms of what's driving the economy. Is it being more implementer friendly or more patent holder friendly? And that tends to shift back and forth with administration changes. So I'll walk you through that and where we stand right now. So since 2013, really, we had several decisions that determined what a FRAND royalty is. Until that date, really, I don't think there was any case law in the US that had set a FRAND royalty rate. That was always discussed between the parties, and I don't think has ever been litigated to the level where the court actually determined a rate. There's been different methodologies. I'll go through some of them. You'll hear, hypothetical negotiation or modified Georgia-Pacific factors, which is kind of the classic patent infringement, reasonable royalty damages approach. A bottom-up analysis where you determine the value of the patents and then apply it to the products, or a top-down analysis where you look at what should the overall burden be on the implementer, and then you essentially allocate that among all the patent holders. And some other approaches we'll go through. If you look at the US cases, I think one thing to keep in mind is that some of these cases are just patent infringement lawsuits where the remedy is a reasonable royalty, or the damages in the form of a reasonable royalty, and that is subject to a FRAND commitment. So the court will determine a reasonable FRAND royalty as a damages award. Some other cases are actually contractual disputes, and the Motorola case was one where implementers asserted breach of contract because the license offer that the patent owners made, the implementer argued was not FRAND, and by doing that they breached their contractual FRAND commitment. The analysis is often similar, but there are some differences. So I think just whenever you look at these cases, it's important to keep in mind, was this a damages case, or is this a kind of licensing contractual case? Has procedural implications, but also really does have some impact on what the court's determination means and whether there's a range or a specific number. Well, I'll talk about the relationship between royalty base and royalty rates. So when Clemens talked about, do you license at the chip level, do you license at the system level, at the car level, at the handset level? US courts have discussed that quite a bit, and there's a term you will see, the smallest saleable patent practicing unit, or SSPPU. The question is, well, should the royalty or the license fee always be based on the smallest element that practices the patent? So if you have a patent, reading on 5G functionality, should you always only look at the modem chip? Or can the royalty base be something different? In the wireless world, often it's the handset. Traditionally, it's been the handset for most licensors. And then there's a question of stacking that we'll talk about. Where implementers will say, you're not the only one that seeks royalty payments, and if I pay every patent holder, every holder of a standard essential patent for my 4G, 5G modem chip, the same royalty, then my royalty burden would be 500, 600, 700% of the value of the product. So there's a question of allocation and apportionment, and if you have 5,000 or more standard essential patents covering a product, how do you allocate among all those patent holders? Judge for this jury decisions is a bit of a specific issue, and then the other thing in the US to keep in mind that if you're a patent owner, standard essential patent owner, you need to be careful when you make an offer to make sure that's defensible as a FRAND offer. There's been lots of litigation in the US where implementers, countersued or sued actively the patent owners for making offers that they argued were either in violation of their contractual FRAND commitment that they made to the standard setting organizations, or brought antitrust actions because they argued that making a a non-FRAND offer and asking for too high of a royalty is abuse of market power and is an antitrust violation or an unfair trade practice. And so lots of cases around FRAND licensing are actually antitrust cases or mixed cases that are brought by implementers. Let me move on here. So I'll talk about Microsoft Motorola because it's such a seminal case, and it's also its 10-year anniversary, I think. 2013 was the case. Hard to believe how quickly time passes here. So this one is really interesting. One, because of the first case that really spent a lot of time analyzing FRAND royalties and actually ending up setting a rate. At issue here was Microsoft's Xbox products that use Wi-Fi technology for connectivity, and a dispute with Motorola. So Motorola had standard essential patents for 802.11 and H.264 standardized technology. Had discussions with Microsoft about royalties for the product, and they couldn't agree. And Microsoft brought this action. So Microsoft sued Motorola for breach of contract by asking for a royalty that Microsoft argued was not FRAND because it was too high. I think the ask was $3 to $4 to $5 per Xbox is I think the royalty that Motorola was seeking. Very much in line probably with what was kind of current practice back then. People were seeking royalties based on the full system. Qualcomm has always done that on handsets, and others have done it in other industries. So what's remarkable, so Microsoft sued for breach of contract, arguing that Motorola had made a contractual FRAND commitment to Etsy, I think, to license these patents on FRAND terms. They said they didn't do this. They asked for way too much. And Microsoft argued that they're a third-party beneficiary under that contractual FRAND commitment. So they brought this breach of contract action in Washington State. So it's a very different setup. Often these cases, would be brought by the patent owners as damages cases. This one was the other way around. So what was so remarkable and why that decision really kind of had started this whole wave of follow-on FRAND cases and was really influential in licensing discussions. Just the rate that the court found to be FRAND in this case was so much lower than kind of the rate that Motorola was seeking. So if you look at the outcome, the court, after long discussion and going through methodologies, expert witness, I think it's a 200-page decision, said that the FRAND royalty for the H.264 standard is 0.5 cents per unit. So half a cent per unit instead of $3 to $4 per unit that Motorola was seeking. And that the royalty for the Wi-Fi 802.11 standard was 3.7 cents per unit. So very meaningful, I think, 100, 200 times less than the royalties thought by Motorola. And so that set off a lot of activity in licensing discussions. I think, licensees really viewed this as a breakthrough in terms of, one, the analysis, and then two, obviously the much lower amounts. And for licensors, I think it was a bit of a wake-up call, and then followed by activity to really argue that this is maybe not the right approach. Where this is way less than what comparable licenses would suggest. What the practice was in the industry, et cetera, for all the reasons that Clemens described just now. So what the court did, they went through what's called a modified Georgia-Pacific methodology. Where they look at different factors to determine what a reasonable royalty is. So that's a classic approach used in U.S. litigation to determine reasonable royalties as damages generally, but then modified because of the FRAND commitment. So went through these factors, that they say it's important. The goal of when these standard-setting organizations, have FRAND commitments, their goal is to promote adoption of the standard and to avoid it's called holdup, that implementers can be blocked from implementing the standards by being subject to royalty demands that aren't supportable. The court did say that the stacking burden is one important factor. That if there are thousands of standard essential patents that are cover a product that needs to be taken into account if the royalty they're setting in this case then is multiplied, and just increases, it creates a royalty burden if it's all stacked together. That's not supportable. The court also said, the goal is to ensure reasonable royalty for the SAP holder. Importantly, said that the royalty or damages need to be limited to the value of the patented technology itself, not any value that's associated with the incorporation of the technology into the standard, which the court said that's the holdup value, right? If we can charge you just because you have no other choice, that is not the value of the technology itself, of the patent that was created. And then it should take into account the contribution of the technology to the standard and the implementer's product, the importance of the SEPs at issue, and also said it's appropriate to look at existing licenses and comparable rates. And in this case, they use pool rates, which I think it was for both standards, they looked at different patent pool rates and said that that is not determinative, but it's an important factor. So at the end of the day, the court went through all these factors. I think the pool rates actually end up being the main driver for the decision. They looked at some of the CISWEL and VIA licensing pools, and then importantly kind of allocated. They said, because this is a subset of all the essential patents for these standards, the rate will reflect kind of an apportionment. And the other thing, I think this is something that Clemens kind of mentioned, should the value be the same no matter where in the value chain you license? And the court said, yes, the value of the patented technology doesn't change based on different pricing for the end product. So the example the court gave, which is I think interesting and informative, said, this Xbox product that sells for $200 that uses the same Wi-Fi chip as an Xbox product with more memory and other features that sells for $400. And the court said it's probably not appropriate for the patent holder that holds patents on the Wi-Fi technology to participate in the other $200, and all the value of the technology around the Wi-Fi chip that is not actually covered by any of these patents. So that's an important factor that other courts have also picked up on. The next important decision is in re Innovatio, same year, also for Wi-Fi patents, where the court set a different rate. It said 9.56 cents per Wi-Fi chip. Instead of the $3 to $36 in this case that Innovatio claimed, based on a percentage of the sales price of the entire product, a router in this case, instead of the chip. So again, a huge difference in the ask and the ultimately the royalty that the court found to be FRAND. I think similar spread as in Motorola. The court here did look at Motorola and applied some of their methodology, but made some important changes, and that this kind of become known as the top-down approach, where it's essentially, so the court emphasized it's the chip, not the end product, that is the appropriate royalty base in this case. There's other cases that say, well, it could be kind of a combination of the two, but we'll talk about that. And then the court said, well, we'll start from the top. We look at what's the average profit per chip. And we say that's the maximum amount that's available as a royalty for all the SEP holders. So they kind of define the pie and say, the Wi-Fi chip that sells for $20 has a, 10-15% profit margin. That's what we start with. That's what's available. So in this specific case, they said, we have a $1.80 profit per chip. And of that, we say 84% of that is allocable to kind of the top 10 of the SEPs that read on this standard. They say there's SEPs that are more important, there's SEPs that are less important, and did some analysis and said, we think the most value should go to the top 10% of the SEPs. And they said those are, of all the 3,000 Wi-Fi standard essential patents, 10% of those should get most of the value, and then we just split it among those patents, and so the $1.51 available royalty becomes 9.56 cents because Innovatio had 19 patents. It's a very kind of mathematical formula where you look at the pie see, this is all that's available, and all the SEP owners need to basically split that somehow between themselves, but it's a finite pot, and you know, so that ends up being a fairly low royalty. You know, the court was questioned whether is that really the right approach, that you look at the existing profit margin and then just share that among the patent owners, or, you know, something that I think Clemens also suggested, you know, maybe the price is too low, right? Because you don't include the royalty burden that would apply to the chip, and your profit margin could be the same, but the price should be higher to take into account the royalties. The court kind of acknowledged that that's not always the dispositive for determining the FRAND rate, but found in this case that that's the right approach. So slightly different from Motorola, you know, especially because you start with kind of a fixed number that's available, and then you start splitting that. Very fact dependent and needs a lot of information that's hard to get, and also controversial, right? Like, how many standard essential patents are there? Are all patents that are declared actually essential to the standard? How important is one essential patent as compared to another essential patent? So it's very, in terms of litigation, it's very involved. You know, lots of expert testimony, lots of studies to come out with the number at the end of the day. But again, one other very influential U.S. decision. And then there was Ericsson dealing. I think it's the third one of the really foundational decision, which took a bit of a different approach. So this was an infringement damages case, also Wi-Fi standard, but routers, laptops were the products at issue there. In district court, so first instance, this is a jury decision, awarded about 15 cents per device for infringement of Ericsson's SEPs. And then the appeals court, the Court of Appeals for the Federal Circuit, where all patent appeals go in the US, vacated and said that this needs to be reconsidered by the jury because the jury instructions were deficient. So in the jury instructions, you know, where here jury, these are the things you need to consider when you determine the royalty. And the Court of Appeals said that those were not correct and were kind of too narrow for the jury to really make the right decision here. So importantly, the Federal Circuit, they reiterated a few things and said, one, the rule of apportionment in US patent damages law is important. It's required to apportion reasonable royalty damages so that they reflect only the value of the infringing features of the product, not additional value added through other technology or additional value added because it's standardized. But importantly, different from Innovatio, the Federal Circuit said it's not improper to admit licenses, you know, as comparable licenses that are tied to the entire value of the product. So there's lots of licenses out there, obviously, that where the royalty base is the entire handset or the entire computer, you know, or maybe the entire car. And the court says it's not appropriate to admit these. You just need to make sure that the combination of royalty base and royalty rate is still proper and fair. So in other words, they said, you know, the combination needs to reflect the value, and you can achieve that by having a low royalty rate based on a high royalty base. You know, so if you take the whole car, maybe your royalty percentage needs to be lower. Or you have a higher rate based on a lower priced base component. You know, what matters isn't really in terms of licensing practice where you look to start, but how the combination of base and rate end up. Court didn't adopt either Motorola or Innovatio as kind of the one methodology. They acknowledged both and didn't think either was wrong or right, but was much more open to how this could be determined. And then also important, I think, different from Innovatio, and it's an important point, is that royalty stacking issue. So the issue that the implementer may need to pay many licensors, not just one, in terms of jury instructions, are only required if there's actual evidence of that. So not the theoretical stacking. So Innovatio said, well, all the patentees, all the patent owners could come and charge. So we divide the little pie we have by 3,000. The Ericsson court said you don't need to do that unless there's specific evidence that you may need to pay some or all of these others. So that's an important distinction in looking at stacking. So then looking at these cases, the key takeaways, generally that FRAND royalties should reflect the value of the technology covered by the standard essential patent at issue, not unpatented features or the holdup value. Smallest saleable patent practicing unit, one is hard to pronounce, but isn't necessarily the right royalty base. It could be, but as long as the combination of the value of the royalty base and the royalty rate are fair, it's okay to license at a system level. I think one thing that comes out of all of these cases is that fixed per unit rates may be much more defensible in licensing discussions than percentage rates. Because this is the expert example, because if you just have a percentage based on a fluctuating value of a product where the value fluctuation is not linked to the patent technology, it's harder to defend that as still being a FRAND royalty, because the value that's added, is based on other technologies. So it kind of conflicts with the first of these takeaways, that you can really only charge for the value of your technology, not for the value of other technology that may also be subject to royalties that's being added to the product. It's not required to use fixed rates, but in licensing discussions, we've seen that it's a lot more defensible if you say, it's X cents per unit, or it's capped at some level, than a percentage that just is completely dependent on total product value versus patented feature value. The approach on stacking isn't consistent. Courts will look at it, but depending on which court you end up in, it may be more or less important. And then comparable licenses are still one relevant factor. But if they are introduced, one, you need to establish that they actually were reached with the parties being aware of FRAND negotiations that are complying with FRAND, and then you need to highlight the distinctions between those licenses and the specific FRAND discussion that the parties are having. And then FRAND royalties obviously may fall within the range. So courts have found that if you have a damages case, that will always come up with one number, that's the reasonable damage. But if you have a FRAND commitment breach case, for example, courts will always say, there's a range that's FRAND. It's not just one number if you make an offer. So you're not in breach of your FRAND commitment if even I find, in the Motorola case, that the royalty is 0.5 cents, that I think as a court is fair and reasonable. But if you offer 10 cents, that may still be a FRAND offer. Okay, I'll quickly go through a couple other things. I think component level, system level licensing, this is an important decision. The FTC had challenged Qualcomm, which is obviously well known for its licensing practices, to only license the handset OEMs, and after at one point in history, no longer license any competing chip makers. And the FTC challenged that. It said, your FRAND commitment it's fair, reasonable, and non-discriminatory, and you're discriminating against the chip makers, because if they want a FRAND license from you, you're saying, no, I only license the handset makers. FTC won that in the first instance in the district court, but was overturned in the courts of appeal, mainly in the Court of Appeals, because the court said, look, this is an antitrust case. Even if that licensing practice were a violation of their contractual FRAND commitment, that's not per se an antitrust violation. So the Court of Appeals didn't say that it's okay to do that under your FRAND commitment as a matter of your contractual commitments, but they said it doesn't matter for the antitrust case. And then the FTC ended up dropping it, and this was also partially because of the administration changes from. So this is kind of an open question whether contractually, if you have made a FRAND commitment and you're a chip maker, and another chip maker wants to get a license from you, whether it's a breach of your commitment to refuse that or not. I think that's an issue we'll see more of in the coming years. The FTC, with the administration change, I think is changing its policy and has indicated that this may be an issue they'll start revisiting. Injunctions quickly in the US. So this is very different from Germany and many other countries, which one of the reasons I think why so much litigation in patent enforcement generally, but standard essential patent enforcement specifically, has kind of moved to other countries, and then triggered this whole litigation game with anti-suit injunctions brought in the US if somebody seeks an injunction in Germany or elsewhere. So in the US, there's no right to injunctive relief as a matter of law. That's a big difference to Germany, for example. There's also no per se rule that injunctions are not available for standard essential patents. It follows the general rule. So since 2006 in the US, eBay versus Merck Exchange is the leading law on injunctive relief, and it's become more difficult in the US to obtain injunctive relief for patent infringement. You have to show irreparable harm. You have to show that monetary damages are inadequate. You have to show that injunction is warranted based on the balancing of the hardships between the parties, and that there's no countervening public interest that is deserved by issuing an injunction. In practice, for standard essential patents, very difficult to get an injunction in the US. Typically, courts will say there's no irreparable harm here and monetary damages are adequate because you already committed to license these patents to everybody, all implementers on unreasonable royalties terms. And really the only case where an injunction may be possible is if you have an unwilling licensee, refusal to pay court-determined FRAND rates, for example, or unreasonable delays, but very, very hard to show in the US. Then same for ITC exclusion orders. I'll keep this one short. So that's a remedy similar to injunctions. And again, there's no per se rule that they're not available for infringing SEPs. This one's very driven by policy because it affects the US market, and US consumers are impacted if important products can't make it into the country. There was one case in the Apple-Samsung wars where the ITC did issue an exclusion order against Apple that would have impacted some iPhones and iPads and other Apple products that the Obama administration vetoed. So they basically undid that decision by the ATC because they said the impact on the US consumers is too large and this isn't warranted. This is also in flux, I think, with administration changes and changes in the composition of the ICC and the FTC, the Antitrust Enforcement Agency in the US. It may go back and forth. I'll go to the policy slide here, just the last one, just to show how enforcement by antitrust authorities and enforcement in the ITC really do tend to shift with different administrations and stated policies. So in 2013, under the Obama administration, the administration issued a policy decision or statement that exclusion orders in the ITC and injunctions may not be appropriate for SEPs because they see a strong public interest to keep these products available for implementers and consumers in the US. The Trump administration had kind of an opposite view, much more SEP holder friendly, withdrew the 2013 statement and said that all remedies should be available to all patent owners, injunctive relief, royalties, lost profits, etc. Exclusion orders. There's no rule that there's a higher standard, different standard for standard essential patent owners. So definitely certainly changed the ITC approach to some extent. And more recently, then another administration change to the Biden administration. They tried to issue a policy statement similar to the Obama administration's one, statement that was perceived to be more implementer friendly and said it's really an exception that injunctive or exclusionary relief would be available for patent owners. But that was very controversial and they ended up not adopting it. So this one was shelved, but they did withdraw the 2019 Trump statement. So now they basically were just back to status quo. There is no policy statement. It's a case-by-case evaluation that the courts and the ITC will have to figure out just based on the general rules. The FTC, the Antitrust Enforcement Agency, they have made statements that do suggest that they're kind of leaning more towards the implementer side and being more restrictive around exclusion orders or finding antitrust violations by implementers, and that they may revisit discriminatory refusals to deal, that was kind of the theory in the FTC Qualcomm case. Is it appropriate under antitrust law to withhold dealing with an implementer who wants a license just because they're at a different level of the value chain. So it's a very kind of general statement, and there hasn't been any specific action, but everybody here is kind of curious where the FTC may take it. So that's it for my overview. Thank you very much.
Thank you so much, Rufus, for your comprehensive presentation. We move on now to Honorable Judge Caroline Tauk. You may start your presentation.
Obrigada, Philippe. Good afternoon, everyone. I want to thank Philippe and Márcio for the invitation and ABPI for hosting this event. I want to greet Clemens and Rufus for the great presentations, and I will apologize, but I will speak in Portuguese because the biggest part of the audience is Brazilian and we have simultaneous translation. And I want to thank all the audience that is here in the name of Celso Santos, Judge Celso, who is my colleague in the court. So it's a pleasure to be here with all of you. Vou compartilhar meus slides, Philippe.
Por favor.
Deixa eu estar em modo apresentação, por favor, tá? Tá pequeno.
Por enquanto, não. Deixa
eu tentar de novo. Agora vai. Agora tá, né?
Sim, agora sim. Perfeito.
Pronto. Bem, como os dois colegas falaram sobre diversos julgados relacionados às STEP, né, os Standard Essential Patents, eu vou falar sobre alguns julgados brasileiros que eu selecionei, e como todos os colegas sabem, nós temos poucos casos sobre isso na jurisprudência brasileira. Então, eu selecionei um mais recente, que é do STJ, que é o mais importante julgado do STJ sobre STEP, né? E um do TRF2, que é o meu tribunal, que é um pouco mais antigo, é de 2015, mas também é bem representativo porque trata dos temas de padrão 4G, 3G, 5G, que é um dos mais importantes para as patentes STEP. Então, muito brevemente, colegas, só para dizer aqui que eu vou, então, focar nessa padronização de tecnologia relacionada ao 3G, 4G e 5G. Então, não vou explicar, claro, o que são as patentes essenciais, todos os senhores sabem, e também não vou explicar o que são os parâmetros para os termos FRAND, né? Porque também isso é a discussão principal do momento. Eu vou tratar mais da jurisprudência brasileira. Esse caso que eu selecionei é muito recente, é do final do ano passado, de dezembro, que foi julgado no STJ. Até onde eu sei, é o primeiro caso de patente STEP julgados no STJ. Philippe pode trazer alguma coisa diferente, se ele souber. Até onde eu sei, só teve esse. E ele acabou em acordo, mas ele tem uma parte muito importante, que é a que eu vou trazer aqui. Como que começou esse caso? Ele começa no Rio de Janeiro, no TJ, é um processo da Ericsson contra a Apple, e nesse caso, a Apple e a Ericsson tinham um contrato de financiamento, aqueles contratos globais, e a Apple utilizava nos seus aparelhos, no iPhone, no iPad, etc., diversas patentes de tecnologia de internet em banda larga, 3G, 4G e 5G, que eram desenvolvidas são ainda, né, desenvolvidas pela Ericsson. Esse contrato de licenciamento global entre a Ericsson, fornecendo o licenciamento das suas patentes para a Apple, começou em 2015 e terminou em janeiro de 2022, e não houve a renovação do contrato de licenciamento. Só que a Apple continuou vendendo os seus iPhones, os seus iPads, utilizando a tecnologia de banda larga 3G, 4G e 5G, sem a autorização da Ericsson, que é a desenvolvedora. E aí, o que se chegou no judiciário foi o seguinte: olha, a Ericsson falou, a Apple estaria impedida de utilizar esse padrão 5G porque ela contém patentes que são de minha propriedade e a Apple não está mais pagando pelo licenciamento, não está mais pagando os royalties. E aí, esse pedido liminar da Ericsson é justamente para que não haja mais a comercialização, nem qualquer produção dos aparelhos da Apple, tanto o iPad quanto o iPhone, utilizando as 3 patentes que a Ericsson elencou lá, que seriam essenciais para a tecnologia 5G. A decisão do agravo, ainda dentro do TJ do Rio de Janeiro, relacionada a esse pedido liminar, ela diz o seguinte: olha, a gente não pode impedir que não é razoável você impedir o uso dessa patente que integra o padrão 5G, que é uma patente essencial, nos aparelhos da Apple. Então, a gente não tem como impedir simplesmente que a Apple, do dia para a noite, pare de comercializar os seus aparelhos que tenham o padrão 5G. Mas aí a própria visão do agravo fala, a gente tem que, então, encontrar uma solução alternativa, porque também a Apple, por outro lado, embora ela não possa ser impedida de utilizar o padrão 4G na sua tecnologia, ela também não pode utilizá-lo de forma gratuita, porque senão haveria um enriquecimento ilícito. E aí que vem a decisão, concluindo, para tentar amenizar esses dois interesses, ela fala, olha, a Apple só vai poder utilizar no território brasileiro essas 3 patentes do padrão 5G da Ericsson, se ela fizer o pagamento de uma remuneração. E aí, o que a Corte utilizou para saber qual era o padrão de remuneração que deveria a Apple fazer? E talvez essa seja a questão mais importante desse julgado. Eles utilizaram um padrão que estava em vigor anteriormente nos termos do contrato de licenciamento global. Então, o juiz, no caso, o desembargador, ele não criou um novo padrão que talvez ele pudesse analisar o mérito dos termos FRAND para saber se o pagamento naquele processo deveria ser razoável, né, não discriminatório, etc. Ele não entrou a fundo nessa discussão, eles simplesmente falaram, olha, nós vamos utilizar como parâmetro a remuneração que estava sendo paga no contrato de licenciamento global que estava vigente até janeiro de 2022. Essa decisão foi dada no final de 2022, eles consideraram que aquele padrão estaria perfeito, então não entrou nos termos FRAND, mas a princípio considerou que era não discriminatório, era razoável porque manteve o valor. E aí mandou que a Apple pagasse, então, $3 por aparelho vendido no Brasil para que pudesse fazer os royalties pagos para a Ericsson. E aí teve uma segunda agravo dessa mesma decisão. No Brasil, para os Rufus e Clemens, a gente tem muitos recursos, então, dessa decisão teve outros agravos. E aí, nesse caso, o entendimento foi no sentido de que deveria a Apple pagar não apenas pelo valor das 3 patentes que a Ericsson estava discutindo no processo, mas deveria também pagar por todas as patentes envolvidas no iPhone e no iPad, um pagamento muito maior do valor que seria o valor anteriormente fixado relacionado às 3 patentes da Ericsson. Esse pagamento relacionado a um contrato global de licença e não relacionado só às licenças das 3 patentes, daria cerca de $200 milhões, o que no Brasil dá uma quantia bilionária, porque a gente multiplica isso por mais de 5. E aí por causa desta segunda decisão, que manda que a Apple pague uma quantia bilionária em reais, que é a nossa moeda, para a Ericsson, em razão não apenas das 3 patentes que eram essenciais, mas de diversas outras patentes da Ericsson, que o agravo, né, essa decisão, acabou abrangendo, gera, então, um recurso que vai para o STJ. É aí que o STJ entra em cena. E o que o STJ fala? Olha, as 3 patentes essenciais que são discutidas são as que a Ericsson trouxe para o processo relacionadas ao padrão 4G. A interpretação que a segunda instância do Tribunal de Justiça do Rio de Janeiro ampliou para conceder a remuneração por todas as patentes envolvidas no iPad ou no iPhone, ainda que fossem patentes essenciais, não estão discutidas no processo, porque é muito mais do que o pedido inicial, extrapola o pedido inicial. E aí, em razão disso, o STJ conclui que o pagamento deve ser proporcional apenas às 3 patentes objeto do pedido, que são as 3 patentes essenciais, e aí determina o pagamento nos mesmos termos que a primeira decisão dos agravos tinha determinado, que é essa aqui, que haja o pagamento de $3 por aparelho da Apple vendido no Brasil, que era a remuneração que coincidia com o contrato de licenciamento global que a Apple estava vigente até janeiro. Só que pouco tempo depois houve um acordo entre a Apple e a Ericsson, e aí, cerca de 3 ou 4 dias depois, houve um acordo entre a Apple e a Ericsson, então a Apple não teve que pagar esses $3 em razão do cumprimento da decisão judicial do STJ. O STJ acabou extinguindo o processo em razão desse acordo que foi feito entre a Apple e a Ericsson. E a gente vai observar que essa realização de acordos no mundo é muito comum, e aqui no Brasil em especial, acaba ocorrendo com bastante frequência nessas patentes essenciais. E o que é importante desse caso, a decisão do STJ foi a primeira que analisou essa briga da Ericsson contra a Apple em razão das patentes CEP. Essa briga ocorreu em vários países ao mesmo tempo, então tinha diversos países em andamento, com processos discutindo a remuneração pelas patentes CEP que a Apple estava utilizando e que eram de propriedade da Ericsson, mas a liminar brasileira, a decisão do STJ, foi a primeira que trouxe uma solução para a questão em relação aos demais países, e aí, depois dessa decisão, é que houve o acordo. Então, o Brasil saiu na frente nesse julgamento aí, relacionado à briga da Apple com a Ericsson. Outro caso que eu gostaria de falar para os senhores é relacionado a um pouco mais antigo, mas também a essas patentes do padrão 3G e 4G. E agora relacionado à Justiça do Rio de Janeiro e ao TRF2. Foi um caso que foi parar no meu tribunal. Como que começou esse caso? É o caso da Bhering contra a ZTE, em que a Bhering fala que, na verdade, a ZTE estaria infringindo a sua patente, por isso que foi para a Justiça Estadual, dizendo que ela estava fabricando, importando, utilizando e comercializando de uma forma geral telefones celulares que adotavam o padrão 3G e 4G de titularidade da Bhering, mas sem a autorização. E aí o juiz de primeira instância defere a liminar lá no TJ, determinando a ZTE que parasse imediatamente a comercialização, porque ela não tinha a autorização para que houvesse essa comercialização. Reparem, então, que foi diferente do entendimento desse que eu acabei de falar para os senhores da Ericsson versus a Apple. Lá determinou, no sentido de que a Apple não seria razoável impedir que a Apple ficasse sem fazer a sua comercialização, mas a Apple deveria ser obrigada a pagar um valor de remuneração que utilizaria como parâmetro o contrato de licenciamento anterior. Aqui, o Tribunal de Justiça considera que a ZTE, que é a implementadora da tecnologia, não poderia mais comercializar. A Justiça aqui não faz uma medida, uma solução alternativa, como fez lá no processo do STJ. E aí, essa ZTE requer um valor de depósito de royalties para ela poder continuar comercializando os seus aparelhos, ou seja, ela tenta uma solução alternativa, dizendo que, como é uma patente essencial, o titular dela não poderia alegar o licenciamento nos termos FRAND. E aí vem a decisão do acórdão de 2015, dizendo que não é obrigado o titular da patente essencial a fazer esse licenciamento em termos FRAND, salvo se houver essa remuneração que tem que ser discutida. Então, nesse caso, a conclusão foi no sentido de que a ZTE deveria estar proibida de comercializar, essa foi a decisão do TJ do Rio de Janeiro, porque ela não havia comprovado nos autos que ela tinha tentado efetivamente negociar, antes do processo judicial, esse licenciamento. Então, essa também é uma diferença para o caso do STJ. A Apple tinha um contrato de financiamento e ela não renovou o contrato de licenciamento. Aqui ficou comprovado que a ZTE não tinha comprovado a tentativa de licenciamento antes de iniciar a ação. No curso da ação, ela pediu para que houvesse depósito de valores de royalties a serem arbitrados pelo juízo, mas não houve essa tentativa antes da propositura da ação. Então, em razão disso, foi proibida a ZTE de comercializar. Esse caso correu paralelo, quase paralelo, né? Foi um pouquinho depois que começou na Justiça Federal do Rio de Janeiro a ação de nulidade. Veio a ZTE, uma vez já ajuizada essa ação na Justiça do Rio de Janeiro, em que a Bhering impede, né, tenta impedir a ZTE de prosseguir na sua comercialização. No curso do processo, vem a ZTE e ajuiza uma ação na Justiça Federal pedindo a nulidade pedindo uma modificação, né, no licenciamento obrigatório, dizendo o seguinte: olha, eu quero que seja declarado que existe um licenciamento obrigatório dessa tecnologia, do padrão 3G e 4G que eu estou utilizando, porque ele é essencial, ele está inserido nas minhas ferramentas, nos meus aparelhos, e aí, consequentemente, que seja limitado o direito da titular da patente de excluir a ZTE da sua comercialização, sem que antes fossem fixados royalties justos. Por que essa ação foi para a Justiça Federal? Porque a ZTE processou tanto a desenvolvedora da tecnologia quanto o INPI, dizendo que também caberia ao INPI informar lá nos sites, nos seus sistemas, que determinada patente deveria ser considerada essencial, teria que ter uma marca lá de que era essencial. Ela pede que seja declarada a existência de um licenciamento obrigatório pela Justiça Federal. E aí a liminar é indeferida, essa decisão é da 13ª Vara Federal, que é de titularidade da doutora Márcia. Ela foi indeferida e concluindo que inexistiam provas de que, de fato, a ZTE tivesse tentado negociar o licenciamento antes do processo judicial, ou seja, no mesmo sentido da conclusão da Justiça Estadual, a tentativa do licenciamento tem que ser iniciada extrajudicial e aí sim depois levada a juízo nesses casos das patentes CEP, é o que a gente consegue extrair desses dois julgados aqui que ficaram então em sintonia. E também da mesma forma que o caso da Apple e da Ericsson, houve a extinção desse processo em razão do acordo global de patentes, elas acabaram renunciando ao direito, o INPI concordou, e aí foi extinto esse processo na Justiça Federal do Rio de Janeiro. Esse é outro ponto que a gente vai tratar agora, para tentar discutir alguns pontos aqui, muito brevemente, eu já estou na reta final, é que nesse caso houve um acordo global de patentes, né, da ZTE, e eles renunciaram ao direito e o INPI concordou. Mas a questão é, e se o INPI não tivesse concordado? Como é uma ação que tramita na Justiça Federal, que a gente tem o INPI, portanto tem o interesse público latente no processo, é por isso que tem o INPI ali, sempre na Justiça Federal, a nossa jurisprudência é que só existe a extinção quando o INPI concorda. É raro a gente extinguir um processo por acordo ou por renúncia quando o INPI não concorda, né, uma vez feita a contestação. E aí, nesse caso, o INPI concordou, foi menos problemático, mas e se ele não tivesse concordado? A gente teria um acordo global de extinção de processos, em que as partes teriam ali feito uma composição, mas continuaria o processo no Brasil por uma questão processual, talvez porque o INPI quisesse levar até o fim o processo. Não tem resposta ainda para esse caso, mas é uma discussão também importante. Quais as conclusões finais, então? Esses dois casos que eu tratei aqui, do STJ e do TJ do Rio, junto com o TRF2, eles terminam em acordo, mas no caso da Ericsson e da Apple, é considerado que o titular da patente não pode impedir o uso da patente, porque já tinha antes um contrato de licenciamento em vigor, e se ele foi extinto, o judiciário acabou mandando pagar a remuneração que estava em vigor quando esse contrato de licenciamento estava vigente. E aí a questão é, parece a princípio que o nosso judiciário considerou que esse contrato cumpria os termos FRAND, né? Porque ele manteve o valor que estava no contrato, só fez uma atualização. Então, a princípio, considerou que esse contrato cumpria os termos FRAND. No segundo processo, ele diz que por mais que a patente seja essencial, ela não exonera a remuneração pelo licenciamento, e esse licenciamento tem que ser tentado antes do processo judicial. E tem que, inclusive, provar que não foi obtido o licenciamento, que o licenciamento não foi obtido nos termos FRAND. Então, é indispensável essa prova prévia antes de entrar em juízo. Existe uma discussão de se seria necessária uma proposta legislativa para a gente ter mais detalhes sobre as patentes CEP no Brasil, o que eu acho que é muito perigoso, porque as questões ainda estão muito abertas no mundo, né, no mundo como um todo, então isso poderia gerar um descompasso aqui para a gente, talvez o ideal não seja essa proposta legislativa. E com relação a essa quarta conclusão que eu trago aqui é o seguinte, essas patentes dessas tecnologias, como a gente sabe, elas normalmente, as patentes são territoriais, né, claro, então elas são protegidas no território nacional, mas os acordos que são feitos, em geral, têm efeitos globais, como esse da Ericsson e o da ZTE. Então, quando é uma ação entre particulares, por exemplo, no TJ do Rio, Apple versus Ericsson, se elas fazem um acordo, não tem o que discutir, o juiz vai acabar homologando como regra, mas se a gente tem uma ação na Justiça Federal que discute uma nulidade ou algum ato que dependa da concordância do INPI, nem sempre a gente consegue extinguir uma ação em razão de um acordo, porque precisa da participação do INPI. E o que acontece, então, se o INPI não concordar? A gente não teve essa situação ainda, mas é algo que também poderia gerar discussões. E, por fim, nós não temos no Brasil aquelas anti-suit jurisdictions, que são as medidas antiprocessuais que são utilizadas por muitos infratores ou por muitos, digamos, implementadores, né, para evitar que haja a propositura da ação judicial pela outra parte. Então, é uma ação que você impede que a outra parte ajuize uma ação. Como a gente tem aqui a inafastabilidade da jurisdição, a gente não tem no nosso dia a dia de jurisprudência de patentes CEP esse tipo de medida, esse tipo de injunctions, né? Esse tipo de medida antiprocessual. E aqui eu acho que não resta dúvida, né? Não é admitido mesmo no Brasil, aqui não tem discussão sobre o caso. Por fim, deixo aqui meu e-mail para quem quiser continuar as discussões. Agradeço novamente ao Philippe e ao Márcio pelo convite. Obrigada.
Thank you very much, Judge Caroline Tauk, for the very clear and precise presentation, as always. Now we move on to our discussion and questions. Márcio, are you there?
Yes, I'm here.
Okay,
Yes.
so I have not only several questions actually to our guests, but I'm afraid we need first to ask our audience for questions, right? So, or maybe if you want to start with questions. So
maybe just want to mention that our president Gabriel Leonardos is watching our panel, and thank for him for all this attention in creating the idea of having the scientific meeting, and which gave us the opportunity to be here. Thank you.
Yes, thank you, Gabriel, for being here with us today. And so we have actually one question here from the audience. Our guests can see, I assume, the question. So if Clemens or you, Rufus, if you want to answer this question, can you read the question from the chat?
I can read the first one. The second one is Brazilian. I'm afraid that Portuguese. I'm afraid that's beyond my.
No, it's in English actually. I'm reading in English the question.
Well, okay, I see two. The first one is about the royalty rights regarding.
Yes, the first one. The second one is actually, it's a message from the president of our association, Gabriel Leonardos. So yes.
I think I understand it now. Yes, indeed. Okay, so let's start with the first question. Yeah, Rufus, you want to go first, or shall I say a few words?
Go ahead. Yeah, I have some thoughts, but it's probably US specific. I'm curious
so
what you
start with the question. So yeah, it's a good question, an extremely relevant question. So let's see, we see products being sold on many markets, and let's say on some markets maybe there are higher profit margins, on others there are lower profit margins. Also and so therefore it is, and also on top of that there are maybe different patent situations. I said that we have roughly 5,000 5G patents, but not every patent is validated in every jurisdiction. So in some, let's say the US or Germany or China, we have a very high number. In other countries, including Brazil, we have a decent number, but there are also countries somewhere in Central Africa or so where we have, let's say, rather a slow number validated. But basically, we have validated in the very most countries of the world. So is it justified to give different rates for these countries? Or maybe even an obligation. So first of all, let me say that most of the license agreements, at least in my business, are global license agreements. So this means you try to make one rate which is globally, and this should, let's say, cover all the different aspects. And let's say when you have, let me just make an example, $1 per device, that might be for markets where you make very high profits, a very good rate, but for other more challenging markets, it might be maybe a high rate, but that is kind of the business practice. But when it comes to the legal situation, I think basically parties are free to negotiate, to agree on everything, as long as it is fair and reasonable and non-discriminatory. But we always have to explain that non-discrimination does not mean equal treatment. It means basically not discriminate, so not different treatment without a fair justification. So it is therefore absolutely possible that you say, for every sale in the US, I want $1. For every sale in wherever in Chile, I want 70 cents, and in Uruguay, I want 50 cents, because to the situation in that market. However, we also looked at the different calculation approaches. Rufus said quite a lot about that. If you look, for example, at the top-down analysis, I think there the different markets don't change so much, because let's say, even if we have in some patents only very low number of patents validated, most of the other companies, the other patent owners, have similarly also a lower number of patents in these markets. So this means that the overall share is probably relatively similar. And it would be very complicated if you would make one rate for every jurisdiction and then special audits and so on. And so therefore, I think it is just business practice to have one rate, which kind of is a kind of average approach, which should cover all. Also, when it comes to the currency, here the same applies. We know that there are more, let's say, some currencies which have less, and some which have traditionally more inflations. And so therefore, that could change. I make an agreement in dollars, which sounds for a Turkish company at day one very reasonable, but then they have a high inflation, and then suddenly their currency, the exchange value then usually goes down, and so then suddenly it becomes every year much more expensive. It is absolutely legitimate to make some adjustment clauses, for example. So here, basically, again, everything is allowed, which helps the parties and which is which in the end is justified and non-discriminatory. So you can negotiate everything. But if, of course, let's say big licensors have their standard terms, which are already accepted by 200 companies in the world, and you are the 201st, and you say, I'm very different, and so therefore I want something completely different, it might be difficult to negotiate that, but it's possible. So there are no limits. Rufus, over to you if you have.
Yeah, no, I completely agree. And I'm a transactional lawyer, and as a matter of negotiation, Paris is absolutely free. You see that all the time, right? That there's different rates in different countries, different ways to measure, to take kind of local markets into account. I think what's challenging, and this kind of goes to what Caroline was saying, and the cases we see in the UK, if courts set royalties on a global basis, right, where it's the same royalty for a global contract where there's limited ability to adjust, and this kind of becomes then the issue of the race to the courthouse. Where do you get the best deal, depending on, are you on the licensee side or the licensor side? And I think we'll see the more divergent the approaches are, so say in the US, it's currently probably not the most patent owner friendly forum, and that's why you see so much litigation in other countries. And I think in Brazil, you may see more, and Germany has seen its fair share, because the patent owners feel they may get a better result there, higher rates, the threat of injunctive relief. And then that triggers the anti-suit injunction, the anti-suit injunction, because depending on which side you're on, you don't want the German or Brazilian or UK court to set a royalty rate essentially for the US, when you feel US courts would set a much lower rate. So I think that's one challenging part, once you're kind of in litigation and there's a lack of alignment, how different countries approach royalties and the methodology and analysis, and the outcomes are vastly different. That I think results then in real procedural strategic fights and multi-jurisdictional litigation to try to block injunctions or suits in other countries. And we've seen that with Germany, now China, US, China, there's a lot of anti-suit injunction and any suit injunctions, et cetera. You can continue that. So I think that's the big challenge going forward, to just the lack of alignment in the approaches.
It was actually Nokia who achieved the first anti-suit injunction in Germany, because there was a parallel case in California filed against us by Continental, and forgive me, but we did not want to have all this in the hands of just this scope.
Yep.
I was about to ask, we have a few questions from the audience, and we do have time for all the questions, but I would like to raise one question to you, Clemens. Judge Caroline Tauk mentioned that anti-suit injunctions are not allowed in Brazil, and but my question for you is about anti-suit injunctions and anti-suit injunctions in the countries you have litigated or where Nokia has litigated. Have you experienced any conflicts or inconsistencies in how these injunctions were treated? Or first question, and second question, sorry, how has this injunction affected the parties involved in a global licensing dispute, and how the overall resolution of the dispute was influenced by such a injunction? So I mean the global license dispute. So if you could address those two questions, please.
Yeah, I mentioned already our experience with Continental. They requested an anti-suit injunction in the US, and then we got an anti-suit injunction, so that in the end they had to withdraw their request in California. And then the case on the matters in the end was then transferred to Texas, and we won the case. So in the end it turned out well, but it's a dangerous field. So first of all, I agree with Judge Caroline and with Brazil and with many other jurisdictions in this world that there should not be an anti-suit injunction, because let's say no country has the right to tell another country what their courts can do or cannot do. These are sovereign courts and sovereign countries, so that just cannot be the place. And of course, the injunctions usually don't address the courts. So the US court doesn't say German court stop it, but it says to the parties, you party immediately withdraw, or you are in deep trouble if you ever come back to the US, kind of. And so then the effect is the same. I also see a decline in the anti-suit and the anti-suit injunctions, because we have seen so many of those over the last couple of years that in the end they were kind of neutralizing themselves. So the one court said don't do this here, and the next court said don't do this there. And so in the end, I think nobody, or they were not really followed anymore. But there was now the WTO complaint by the European Commission against China. They were complaining about their anti-suit injunction practice. And I think this has just the existence of that complaint has already had some effect. So first of all, that these anti-suit injunctions don't really work anymore, because companies then get anti-suit injunctions elsewhere. And secondly, because China is, let's say, very much under observation here. So therefore, I think I've seen a quite decrease here. And that is good. But my overall comment in the end is it should not influence the negotiations. And especially it would be better if people talk, let's say, more with each other and less about each other. So this means better meet at the table than in the courtroom. That would, in the end, help everybody. But yeah, that's maybe wishful thinking.
Okay, thank you. Márcio, would you like to ask, to raise a question, or should we?
Maybe as we have a lot of questions from the audience, actually, we had during the presentation more than 50 participants during the entire presentation, a great number. So let's see. We have one of the questions which talks also about the proposals from the European Commission. Yeah.
Yes. So Clemens, would you like to reply to this question from Gabriel?
I love to, because I have a very strong view here. Yes.
Which would be one of my questions.
Yeah, let me just say in one sentence for those who are not familiar with that. So the European Commission has drafted the regulation, which is now in the legislative process, so it needs to go through Parliament and through the Council and so on. But what they have drafted is that before you can enforce an SEP, you must go through in the end, a kind of mediation procedure by the European IP Authority, EU IPO in Alicante in Spain, which can take more than 9 months, and only then you are eligible to file a patent infringement action. And I think it's let's say it's completely out of reality, just for a number of reasons. So first of all, I think according to fundamental rights and constitutional reasons, it is very difficult to limit the access to justice, the access to court that dramatically. So basically, I forbid people to go to a court. If my patent is infringed and I'm not allowed to go to a court, I need to go to authority. And so therefore, I think I have very high doubts whether that is possible, whether the the European Court of Justice would accept that. The second point is it's a monster. So they want, let's say, that every single SEP will get listed, will get declared, and you need to provide, that there will be experts who are reviewing each and every patent. And I mean, first of all, it's a monster because there are so many patents, and in the end, is it really necessary to look into each and every patent? I mean, that is not what happens in normal licensing negotiations. You look at a short list, at a proud list, something like that, and then you get an idea of the value of the portfolio, and then you can negotiate. So it has very little to do with reality. It creates enormous costs, and it does not even add much more certainty, because if there's an examiner who looks for 2 hours at the patent, or maybe for 5 hours, if I look in some patent infringement cases where you have huge teams of lawyers who look into the prior art, the infringement over weeks and months, so then you can ask what is the value of these 5 hours, and it costs a lot, and the result is very little. And then my last point is that the European courts are not all courts in the world. So this means the result might be that these patent disputes are just shifted to other parts of the world. And we see that Indian courts, for example, are getting better and better in understanding and deciding on these technologies. Brazilian courts have more and more experience also in SEP matters, and the US anyway with the ITC and very high qualified courts, and the UK courts. UK left the EU, so it's not subject to that regulation anymore. I think all the attorneys in London, they opened bottles of champagne when they saw this draft. So it will just lead to the result that probably patent owners will go to other courts, and so therefore I think it's nonsense. And I hope that there will be heavy amendments before it goes to the final vote, or maybe that it even doesn't pass the parliament.
Perfect. Thank you, Clemens. So we have 2 questions for the audience, from the audience. The next one, if we follow the order, would be again for you, Clemens. So maybe we can check the last one, which could be actually for Rufus. So maybe Rufus, would you like to answer the question from Carlos?
About arbitration.
Yes.
Yeah, that's an interesting one. So I think, I mean, in general, I do think it's a useful process. You know, outside of SEPs, we see that a lot of parties kind of are willing to avoid litigation, to have mediation or arbitration. The problem is, you know, I think you need a commitment from both parties to do it ahead of time, and usually then an agreement on the process, and that to negotiate that, I think may put you in the same position. Are you ever going to get to arbitration? There's no mandatory process. It sounded from what Clemens described, you know, it's kind of in that direction with a very bureaucratic, cumbersome process, you know, under the EU proposal. Which on that one, by the way, I think, you know, from a US perspective, we tend to look at things maybe a little more practical. I think that seems is just set up for failure. But what it would probably do, if you know, we would look at it, it's so cumbersome that the parties may prefer to actually reach an agreement before they have to go there. You know, on arbitration generally, I think the issue is, are you going to have some rules that help bridge a huge gap? I think you know, how far the parties are on the terms is important, right? If you're talking, you know, $3 versus 3 cents, is an arbitrator really going to get you closer? You know, unless you have a procedure like baseball arbitration, where you know, you kind of have to meet somewhere in the middle. Yeah, so I think, you know, in the US, that's also a discussion, like how do you make the process, especially how do you avoid kind of the litigation battle and the international, you know, forum shopping. That's a big concern, I think, for the current administration too. So there are discussions, or are there processes to help manage that, to really kind of force the parties to negotiate before they can go to litigation. There's nothing specific there yet, but that's definitely where parties here try to go, to limit the impact on the market, on consumers, to have products not be banned, to have business continue and work out financial issues essentially in a fair manner. That's kind of the general goal and approach that we think we see here. And arbitration could be good for that if you find a way to make the process work if parties really are on different ends.
Thank you, Rufus. And before going to this question, which would be for Clemens, eu tenho uma pergunta para a juíza Caroline. Você fez uma observação muito interessante, que seria prematuro pensar em uma normatização do tema no Brasil, considerando que o tema é extremamente complexo e ainda muito pouco debatido no Brasil. Você acha que já há lições que o Brasil possa aproveitar do que vem sendo discutido e principalmente decidido lá fora, tanto nos Estados Unidos quanto na União Europeia?
Com certeza, acho, tanto que teve essa última decisão agora da Corte de UK, né, sobre o caso da Lenovo, que também trouxe aprendizados importantes para a gente, super recente, relacionado às patentes CEP, e tem o caso de uma das perguntas aqui também, que falaram da Comissão, né, da União Europeia. Então eu acho que é como o caso da lei da inteligência artificial, do marco legal da inteligência artificial que estão fazendo agora. O Brasil acabou querendo sair na frente para disciplinar um caso que a Europa demorou anos para conseguir regulamentar e disciplinar. Então, talvez fazer esse mesmo movimento no caso das patentes CEP vai ser um grande erro, né? Então, acho que precisamos sim acompanhar muito o que está acontecendo lá fora, aprender muito pelo que o Rufus e o Clemens trouxeram. Já deixa claro que a nossa própria jurisprudência ainda está engatinhando nesse tema em relação a deles, né? Então, temos sim muito que acompanhar antes de ter qualquer movimento legislativo nesse sentido. Na minha opinião, eu não sou legisladora, se alguém propuser o projeto, não temos que fazer. Philippe, eu vou aproveitar e vou pedir licença para eu me retirar, só porque eu tenho um voo para pegar e eu preciso sair para o aeroporto. Me desculpe, achei que fosse terminar um pouquinho mais cedo.
Imagina.
Mas foi um prazer participar. Thank you, Clemens and Rufus, for sharing the panel with me. It was a great pleasure to be here. I am more than happy to be in ABPI with all of you. Thank you, Philippe and Márcio, and hope to see you soon.
Agradeço mais uma vez a participação, sempre contribuindo com exposições valiosíssimas aqui para todos nós. Muito obrigado, Caroline. Espero contarmos com a sua participação em novos eventos da ABPI.
Obrigada, Philippe. Até a próxima.
Até a próxima.
Tchau, Márcio.
Rufus, Clemens, Caroline had to leave. She's taking a flight very soon, so she had to leave now. But we can continue with our questions. So we have another question from the audience. Maybe this one would be for you, Clemens, from Philippe Myla. Can you see the question here from in our chat?
Yes, let me just take 1 second to read it.
Yes, take your time, no rush.
Yeah, the essential facilities doctrine. Well, let's say, of course, it is let's say these cases are a clash between patent law and competition law. And it's kind of the nature that there must be a clash, because in the end, patent law is about exclusive positions. You make an invention, and so therefore it belongs to you, and you can decide whether you want to practice or want to license or not want to license. And then you have competition law, which basically says you should avoid monopolies, so should you, or these kind of exclusivities. So therefore, it of course must be a clash. I think there have been some discussions about essential facilities. I'm not sure it really works well for these kind of SEP cases. And one of the reasons is, let's say, strictly speaking, it must not necessarily be an essential facility, because there are also competing technologies, competing standards. We had cases where we were enforcing 5G patents, and then there was indeed the argument, well, is it essential facility because there are also 4G networks which you can use? but well, of course, let's say the patents might be by quite similar parties. But I think, honestly, these essential facilities, it's not really made for these kind of cases. If I hear about essential facilities, I think about an airport or a harbor, let's say, where you have one big airport in a city or on an island, and either you can land there or you cannot, and then so you need access to that. I think actually that the competition law approach, which we see in Europe, works relatively well, so that you say that you have exclusivity, you can enforce a patent, but since, let's say, since you are maybe in a market dominant position, you need to treat everybody who asks for a license without discrimination. I think this works quite well. I don't really see how applying an essential facility doctrine would here improve the situation. Because in the end, what we need is that we want solutions, and the solution is not only the access to the standard is quite easy. And there were several German Supreme Court judgments. I mentioned one already, this Higher, where exactly the court also referred to essential facilities. Yeah, the difference is, let's say if I don't get access to a harbor, I will stay with my ship on the ocean. I will not make it to that island. If I don't get access to Nokia's patent portfolio, what happens? I say it in my own words, people don't care. They still practice the standard. And that's what we all the time see. There are many companies out there who never asked for a license. So therefore you see there are quite big differences to these classical essential facilities. So therefore I think essential facilities doctrine does not really bring us here much further.
Yeah, I'll add from the US perspective, I think this is one of the areas where it's difficult in the US under antitrust law. This was the FTC Qualcomm case, right, where discriminatory access was one of the issues. Who do you license? Can you refuse licensing at the component level, for example? I do think that may be an ongoing question in the US, and that statement I was referring to from the FTC, that they will pay more attention to what they say fraudulent and inequitable practices, including discriminatory refusals to deal, which tend to create or maintain market power. So there may be more attention. I do think it's very difficult to enforce, and that was ultimately the reversal of the Qualcomm decision. That look, maybe it was a violation of your FRAND commitment, but it didn't really impact the market because you are licensing at the implementer level, and they didn't find that other chip makers were precluded from participating in the market. They didn't get the license, but they were selling to licensees. So I think it'll get more attention here. I don't know where it's going to come out. To me, it's always another angle to get really at the same problem, right? What's the fair rate, and under what conditions does everybody have access? I don't think any of the SEP owners are really about refusing access. It's about what's fair compensation for the access, right? And so it's a bit of a red herring, to address it from a competition law level versus, trying to figure out a path to balance these interests just on a commercial and economic level.
Just mentioned that here in Brazil, we had a decision from the antitrust agency, the CADE, Conselho Administrativo de Defesa Econômica, about the matter. They did not issue the decision based on the essential facility doctrine, but still, I believe that the decision gives a good framework for balancing the interests of the parties. And so just a comment that we had already one decision in the Ericsson PCL case.
Rufus, I have a question for you. You mentioned during your presentation that the approach on stacking is inconsistent. How should you address the issue of licensing essential patents when there is a potential for royalty stacking?
Yeah, so I think two answers to that from in negotiations is one, and how do the courts do it is another. So the courts here, the inconsistency is, in Innovatio, they said, well, we basically consider stacking always, right? We look at all the SEPs and we divide the pie among all of them, even though you may not end up actually paying some of them because they never go after you. In Ericsson dealing, the court said, well, this is what we're looking at. One case, you need to instruct one jury what the right royalty is here. You know, there aren't 20 others who are also asking right now, and so you don't have to include that as a theoretical concern. To me, so that's kind of just how cases and judges approach it. And obviously, you know, you won't get sued by every SEP owner, but you may, right? It may add up. So once you've set a royalty and you say that was FRAND, and then you have the next case and you pay twice or three times or four times, it could easily stack up to be a range that's no longer supportable. I think it should generally obviously be a part of you know, establishing the rate, whether that's in negotiations or you know, by the owners. And we see more and more pools because, you know, it becomes clear, like Avanci and in automotive, you know, that is kind of one way to address stacking, right? That you do get together and you say, okay, the cumulative burden for you to get access basically to all our patents together is X, and that, you know, we think is a fair rate. And courts will probably look at that more. That was what Motorola did. You know, you can't just add up, you know, and say, well, it's $3 for everybody. You know, and parties like Intel and Apple here have made policy statements where they kind of calculated, well, if we just extrapolate this, the royalty stack on a modem chip, you know, we pay $3 to X, and you add that up to every SEP owner. That easy can become too much. So I think there's a bit of self-regulation on the patent owner side to take that into account when they set their rates. I think an incentive to maybe pool or have access via pools is important, especially you know, for industries like automotive or IoT, et cetera, where you have lots of products, you know, lower value products in some cases that practice. We just need to enable kind of affordable access. And I think that's in all parties' interest, right? The SEP owner side, if the royalties and the total burden is too excessive, I think you'll just create so much more pushback and make your own life more difficult too. So the pooling approach, I think, is good and addresses stacking, and courts here will just take different approaches. I think obviously the more theoretical stacking you take into account, the lower the rate will be for every single one.
Okay, thank you. Well, Márcio, would you have any other questions?
No, I think that as we are reaching almost 2 hours of this great panel, maybe we could go to the final remarks. And
yes, if we don't have any questions from the audience.
No, I just got no additional questions. Yeah.
Yes, from my end, I don't have any other remarks. So we had a great panel with brilliant presentations. Thank you so much, Clemens and Rufus, and of course, Caroline Tauk. We had to left earlier to take her flight. I would like to thank everyone for being here today virtually. To extend special thanks again to Rufus, to Clemens, and to Caroline for the comprehensive presentations, very clear and precise. And Márcio, please, for your final remark.
Yes, and thank you all. Also Philippe, Rufus, and Clemens.
And well, thank you everyone for being with us today. And yeah, we wish you a great weekend, and bye-bye.
Thank you very much.
Philippe, for the invitation. It was a pleasure.
Yeah,
Bye,
likewise.
everyone.
Thank you.
Thank you. Bye-bye.
Thank you. Bye-bye.
A propriedade intelectual é responsável hoje por até 80% do valor das empresas. Mas isso não acontece apenas porque as empresas dão valor à sua propriedade intelectual. A propriedade intelectual vale muito porque a sociedade dá valor ao esforço de solucionar seus problemas e de lhe criar oportunidades. Nosso congresso desse ano vai reunir especialistas em propriedade intelectual, juristas, economistas do desenvolvimento e da inovação para nos guiarem nessa importante discussão. O pano de fundo escolhido não poderia ser melhor: as maravilhas da cidade do Rio de Janeiro. Para comemorar seus 60 anos de existência, a ABPI reunirá os participantes nos mirantes deslumbrantes do Pão de Açúcar, ícone turístico do Rio de Janeiro, aclamado por visitantes do mundo inteiro. Durante 3 dias, teremos a oportunidade de nos encontrarmos, fazer negócios e, sobretudo, de discutir e aprofundar nosso entendimento do papel da propriedade intelectual frente aos desafios brasileiros. Da consolidação do agronegócio ao desenvolvimento do turismo e de indústrias avançadas, da transformação digital e da transição energética ao estímulo ao empreendedorismo e à inclusão social. Participe e se engaje com o compromisso social do Congresso da ABPI de 2023. Esperamos vocês de 20 a 22 de agosto na cidade maravilhosa do Rio de Janeiro.